Before I begin, how many people will be making a statement? Three. We will go on the record in the matter 24 CF 79, State of Wisconsin versus James Brown. The state appears through District Attorney James Renicky in person. We have Mr. Brown appearing in person with counsel Eric Pangburn. We're set here today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Mr. Renicky, can you please recite the agreement? Well, first, is there a plea questionnaire waiver of rights form?
There is.
I would note I did review the jury instructions that I have on my computer, but I wasn't able to print them, but we did review them.
So I apologize that they're not attached.
That is okay. Can you please recite the agreement for the record?
My client is going to enter a plea of guilty to counts 1, 6, and 8. The remaining counts are to be dismissed and read in. We're recommending 3 years probation. We didn't discuss any specific conditions of probation. I assume that the court will order what it thinks is appropriate based on the facts. We're not asking for the court to order any additional incarceration based on the fact that Mr. Brown did spend 96 days in jail unable to post a cash bond in the file that was this case before it was dismissed and refiled.
All right. Okay. Mr. Renicky, this is a very serious case. There are 14 felonies, predominantly H felonies with some I felonies and 2 G felonies, making this very serious. 3 of those H felonies are attempts. It has been a global offer with regards to these charges, down to 3 counts, 1 H felony, actually 2 H felonies, and an I felony. Can you please state for the record how this agreement is in the public interest?
I believe it's in the public interest, Your Honor, because we're getting a conviction on 3 serious felonies. The defendant does not have a criminal record. It has fairly unique facts to the case. This was a what I would say, jurisdictional investigation. And in terms of the underlying behavior, we think the 3 felonies that he's pleading guilty to adequately cover the actual facts of what happened. And he's taking responsibility not only for the 3 counts that he's pleading guilty to, but he's also agreeing to the dismissed and read-in counts, which could be considered at sentencing. And so, therefore, we do believe it's in the public interest.
And you are in victims' rights compliance, is that correct?
Yes.
All right. Before I proceed with a plea or taking a plea and moving on to sentencing, I'm going a little bit out of order as I would like to have the victim statements. Ms. Bauer? Yes, please go to that table over there. You can either state your name and or occupation if you wish, or just your initials.
Okay. Noah Lucas Barker, Deputy Burnett County Sheriff's Department. So in the late morning of July 2nd, 2023, I came home from work. I parked my squad car, walked inside my house, and took off my uniform like I always do. I laid in bed and stared up at the ceiling, thinking about what had just happened. I did not regret my actions. I knew what I had done was what we all trained for as law enforcement. Still, I lay there with my mind racing. Did I do everything I could have? Were there other options I could have chosen? I kept telling myself my partners were alive, EMS and fire were still alive, Mr. Brown was still alive. I told myself my wife and daughter still had a husband and father. Over the next couple days, I received numerous calls and texts asking how I was. My response was always the same. I'm fine. I'm glad everyone's okay. I'll see you guys soon. But I was not okay. I was not myself. I did not feel like myself. I would look in the mirror and see an emotionless, pale human that I did not recognize. I was off for work for around 3 weeks. I spent that time trying to distract myself, seeing friends, working on the house, and visiting family. When I did return, I did not feel the same. The world looked different. Work felt different. I caught myself second-guessing decisions I made on the job. I caught myself handling calls for service differently than I had before. Over time, the numbness subsided, and I began to see myself in the mirror again. Work and life carried on, and the memory of July 2nd was not always in the forefront of my mind. And now we are here today. In the words of Haile Selassie, throughout history, it has been the inaction of those who could have acted, the indifference of those who should have known better, and the silence of the voice of justice when it mattered most that has made it possible for evil to triumph. It is my belief that only 3 years probation for Mr. Brown is allowing evil to triumph. Mr. Brown, due to your actions that night, I made a decision I never thought I would have to make in law enforcement. Your actions took a part in my humanity I will never get back. I hope you find the help you need. Thank you.
Ms. Bauer. Please state your name and/or your initials before beginning.
Corey Ray Barnett. I'm the chief of Grantsburg Fire Department. July 2nd, 2023 has set me back years. Let me explain. As a Marine, I was deployed to different combat zones and spent a little over 3 years of my life fighting against foreign enemies. I was wounded a few times and once critical, but due to great field doctors, I pulled through. I have seen more in my lifetime than anyone should ever have to. I was single, didn't have children, so I accepted that there was a high probability that I would either be killed in action or scarred for life. I have the physical scars as a reminder of what happened, but the mental scars never go away. When I came home and left the Marines, we were shown the door and expected to adapt back to civilian life. I spent years coping with the physical and emotional pain with alcohol. I never thought I had a problem. I was fine. Once I met my current wife, she saw what I couldn't. She saw the pain. She saw the nightmares and fighting in my sleep. She saw I was drinking to cope with everything as a self-medicating strategy. Only after she became pregnant with our first child, I started to seek help from the VA and trying to put my life back together and become a contributing member of society. There are many ups and downs with my recovery, but with time, things started to get better. I joined the fire department in 2010 and started to put efforts into the community that I lived in. I continued my healing by being in veterans groups and still seeing different doctors. I felt that I was becoming more comfortable in my life and being in public. All this healing to get where it took nearly 15 years of continuous care. I finally got to a point where I didn't need the doctors and the psychiatrists as much as I did. I was in a great spot with my wife and kids and being sober. All of that changed on July 2nd. When my firefighters and I went to help Mr. Brown, who was laying in the roadway, we were just doing that, helping. We all jumped into our roles, trying to make sure that he was okay and what kind of assistance he needed. Knowing that he was a Marine like myself, we were able to talk and keep things somewhat calm after he tried to fight an EMT. All we wanted to do was help. I knew that law enforcement was a ways out and not completely in a hurry because things were under control and we were able to get him back in his residence. That's when everything changed and my life was sent spiraling back into a dark place. Every Marine is trained as a rifleman first, so every single one of us can pick up a weapon at any time and fight no matter what job you hold. There are 4 weapon safety rules that are ingrained into and to us from day one of boot camp. Treat every weapon as if it was loaded. Never point a weapon at anything you did not intend to shoot. Keep your finger straight and off the trigger until you're ready to fire. Keep your weapon on safe until you intend to fire. These rules are ingrained into every single one of us, as well as my children and anyone I work with on firearm safety. When James turned the corner into a firing position and pointed a gun at me, I thought I was going to be shot and possibly never see my wife, kids, family, and friends ever again. In all my years in the military, I had a way to defend myself. July 2nd, I was in the open and very vulnerable to whatever he decided to do in that moment. I instantly went back into my killer be killed mentality that I had worked so hard to diminish for my life. I do not have a flight mode within my body. I was trained to fight, and that's just who I am. I never wanted to be put in that mental position again, but there we were. As he came walking back to the fire department, I had to worry about my other firefighters' lives that were still in the hall. My job was to protect them or die trying. My thought went to my wife and kids, and that I never got to say goodbye as my pager sounded to respond to an ATV crash with injuries. They would have had to grow up without a dad and my wife a widow. Luckily, none of that came to fruition. What did, though, is a downward spiral in my mental health. I became withdrawn. I started high drinking again. I became a different person just because of one person in my mind that was ready to kill me and my firefighters. I have missed several weeks of work seeing doctors, becoming sober again, and working on a better person. All that I had accomplished prior to this was completely wiped away in a matter of a few hours. I had to start back over at square one. I've had to get help from my firefighters that thought they were going to watch me die. My life that I had built started to crumble. My wife was ready for divorce because she couldn't stand and didn't want the kids to see what I was becoming. So from that day in July, I fell back to bottom and have spent every day fighting to become better. When I read the plea agreement that was offered, I became more than angry. How is it fair for us that we're affected and continually are? A million thoughts came to my mind. How can someone aim a loaded gun at someone, fight with others trying to do their jobs, cause psychological setbacks in our lives, get slapped on the hand, and told to have a good day? I was ready for my day in court and James being held accountable. With this plea agreement, I don't feel that there is any justice being served at all. When you can get more jail time for an OWI or punching someone than actively pointing and ready to shoot someone. This is not justice for myself or any of the others involved. I do not think probation is enough. Thank you.
Thank you. Ms. Bauer?
My name is Trevor Kyle Tex. I was listed as a victim in the case. I am not a victim of what Noah Deputy Barker, Fire Chief Corey Barnett went through. I'm a victim because James made some threats at the hospital. We had to go hands-on and fight with him to the ground. However, when I was informed of the plea deal, initially I thought 3 years of probation for a conviction, to mark a conviction on a sheet of paper. And the DA kind of said that today. We're getting 3 convictions of felony charges. What in that makes this right? Nothing. 3 years of probation for what Mr. Brown put Deputy Barker, Fire Chief Barnett, and the others through. 3 years of probation aren't nearly enough. As a conviction, yeah, we get 3 felony convictions out of, I think, 14 charges. 3 years of probation ain't nowhere close. to what Mr. Brown should have to go through. Thank you.
Mr. Brown, I have in front of me a plea questionnaire waiver of rights form, as well as an addendum to the plea questionnaire waiver of rights form. Did you go over this document with your attorney?
Yes, ma'am.
Can you please pull the microphone closer to you?
A little closer. Yes, ma'am.
Did your attorney go over this thoroughly with you?
Word for word.
And he read it exactly word for word?
Yes, ma'am.
And so you understand everything completely?
Yes, ma'am.
And if you didn't understand something, did you ask him to explain it?
Yes, ma'am.
And he did so.
Yes, ma'am.
You are pleading guilty to 3 counts. Count 1, intentionally point a firearm at a law enforcement officer, a firefighter, an emergency medical technician, etc., an H, felony. And as I understand this, this may not have been a legitimate real firearm, but it was a firearm that was believed to look like a firearm, correct?
Actually, in this case, for count 1, it really was a firearm. It was a 9mm pistol that was loaded.
So it wasn't, this was not the
BB
pellet gun or the BB
No, the
gun?
BB gun was the rifle. That was the second event. But this particular count was the pistol that actually was a pistol, which was loaded as a 9mm.
All right, so this is an actual firearm, the 9mm firearm that you in fact did point at a law enforcement officer, a firefighter, or an emergency medical technician, a Class H felony. Is that correct?
Yes, ma'am.
And you're pleading guilty to count 6, battery or threat to a judge, prosecutor, or here, in fact, a law enforcement officer, a Class H felony. Is that correct?
Yes, ma'am.
And you're pleading guilty to failing to comply with an officer as a person or person into custody, a Class I felony. Is that correct?
Yes, ma'am.
And there are 11 other counts that are being asked to be dismissed, but read in for purposes of sentencing. And I'll get over what that means, but you understand that. Is that correct?
Yes, ma'am.
You're 37 years old. You have 13 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove as to those 3 charges to find your guilt beyond a reasonable doubt?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalties that you face?
Yes, ma'am.
You are not receiving treatment for a mental illness or disorder. Is that correct?
Yes, ma'am.
Although I thought that I can recall at least another hearing, maybe not with Mr. Pangburn, but previous case where you had a different counsel that you stated to the court that you suffered from some types of mental illnesses or disorders, such as PTSD, perhaps anxiety, or other types of mental illnesses or disorders. Is that correct?
Yes, ma'am.
But you are not receiving treatment for those. Is that accurate?
Yes, ma'am.
Are they affecting your ability to comprehend or understand what's going on here today?
No, ma'am.
Are they affecting your ability to comprehend or understand anything that's happening or affecting this case or anything about this case?
No, ma'am.
Or your constitutional rights or the facts concerning this matter?
So she's asking if you're mental illness is interfering with your understand what's going on. No, yes. No, ma'am, everything's good.
You have not had any medications, alcohol, or other drugs within the last 24 hours. Is that correct?
Or ever since I got arrested. Yes, ma'am.
All right. Because you're being charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Do you understand that by pleading guilty to these charges, you're waiving and giving up these rights?
Yes, ma'am.
Do you understand you'll no longer have the right to a trial? You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty, and you will no longer have the right to have the state prove your guilt to these charges beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
A loaded gun, terrified first responders, and a plea deal that left everyone stunned. Victims say their lives were changed forever, but is 3 years probation really justice? This emotional courtroom showdown has people asking one question: did the system get it wrong? Watch until the end and tell us what you think. Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more shocking courtroom moments.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes, ma'am.
Do you understand, with regards to these charges, that with count 1, intentionally point a firearm at law enforcement officers, that the state would have to prove on or around July 2nd, 2023, in Grantsburg, Burnett County, Wisconsin, you intentionally pointed a firearm at or towards the fire chief, Corey Barnett, who was acting in an official capacity and who the defendant knew, who you knew or had reason to believe was a firefighter. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand that upon conviction of this Class H felony, you face a fine of up to $10,000 or imprisonment up to 6 years or both?
Yes, ma'am.
Do you understand that with regards to count 6, threat to a law enforcement officer, the state would have to prove on or around July 2nd, 2023, in Grantsburg, Burnett County, Wisconsin, you intentionally threatened to cause bodily harm to Sergeant Chad Brugman, a law enforcement officer, without his consent, and at the time of the threat, you knew or should have known that Sergeant Chad Brugman was a law enforcement officer, and the threat was in response to an action taken by the law enforcement officer in an official capacity. Do you understand what the state would have to prove for this Class H felony?
Yes, ma'am.
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment up to 6 years or both?
Yes, ma'am.
Do you understand as to count 8, failing to comply with officers' attempts to take you into custody, the state would have to prove on or around July 2nd, 2023, in Burnett County, Wisconsin, you intentionally refused to comply with an officer's lawful attempt to take you into custody, and you retreated or remained in a building or place, and through action or threat, you attempted to prevent the officer from taking you into custody while doing each of the above, remained or became armed with a dangerous weapon or threatened to use a dangerous weapon, regardless of whether you had a dangerous weapon. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand for this Class I felony that you could be, upon conviction, fined up to $10,000 or imprisoned up to 3.5 years or both?
Yes, ma'am.
Did your attorney thoroughly go over the jury instructions in which state the elements that the state would have to prove your guilt for those 3 crimes with you thoroughly?
Yes, ma'am.
All right. Now, do you understand you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
Do you understand that there is an offer, an agreement here between the parties for 3 years of probation?
Yes, ma'am.
And that there would be certain conditions that you would need to follow while on probation. Do you understand that this agreement that's been reached between the state as well as the defense is not binding on me, the court?
Yes, ma'am.
Said differently, do you understand that it's my discretion in what I sentence? And for each of these charges, which could mean that I could sentence you up to the maximum possible penalty for each of these charges if I thought it was warranted.
Yes, ma'am.
Do you understand that in my sentencing discretion, I can sentence you with different sentences for each of these different charges? Again, if I thought it was warranted based upon the facts of this case. Do you understand?
Yes, ma'am.
And do you understand that could mean something such as a consecutive sentence for the sentences for the charges, or they could be concurrent? Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty, please?
Yes, ma'am.
Do you also understand that there are certain other charges here, 11 other charges that are being asked to be dismissed and read in? Do you understand that by having dismissed and read in charges, you are agreeing that the court, myself, can consider these offenses and that the state is relieved from their obligation in establishing a factual basis for these offenses? Do you understand that?
Yes, ma'am.
Do you understand what that means?
Yes, ma'am.
This is in exchange for the promise that the state will not prosecute you later in the future for these additional offenses, and your slate is essentially wiped clean for all of these crimes. However, do you understand that it essentially could expose you to the likelihood of a higher sentence for the charges that you're pleading guilty to, as long as it doesn't go above the maximum possible penalty? Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas here today?
Yes, ma'am.
Do you understand that the court looks at character of a defendant and that a sentencing court may consider those uncharged and unproven offenses, but also the facts related to those offenses for which you haven't been found guilty, but which have been now asked to be dismissed and read in? And do you understand what that means?
Yes, ma'am.
All right. Did you review the criminal complaint with your attorney?
Yes, ma'am.
And in particular, there is a section, and it's called the probable cause section. And it essentially says what happened that day and why you were charged with the crimes. Do you remember that?
Yes, ma'am.
And it's very lengthy. This is a very long criminal complaint. It's 14 pages long. And you remember those facts essentially, correct? You went over that with your attorney?
Yes, ma'am.
For the most part that you can recall, are those facts accurate?
Honestly, from what I can recall, yes, ma'am.
What do you recall from that day happening in your own words?
I recall buying the alcohol. I recall not sleeping for 3 days. I recall buying the alcohol so that way I could possibly get some sleep that night. And then fall into a spiraling state of depression and aggression due to, as I have claimed before, PTSD that I actually had long before I even joined the Marines. Something that...
Now, you
No,
reviewed the
let's-
criminal complaint with your attorney, correct?
Yes, yes, ma'am. Sorry.
And again, in looking at that probable cause section, Mr. Pangburn, do you have that on your computer?
I do.
And can you show Mr. Brown that probable cause section in which it goes over what happened that day and the actions of Mr. Brown and the police departments and the sheriff's department, as well as the fire departments and the emergency response teams and all that occurred that day?
Oh, okay. Is that right? Yeah.
Yeah, I mean, what Mr. Brown has told me, Your Honor, is he does, because of his intoxicated state, doesn't remember a lot of what happened, but he's not disputing the recitation of the facts that the various law enforcement officers have described as outlined in the complaint. That's why he's pleading guilty.
And you understand that, correct, Mr. Brown?
Yes, ma'am.
And you also understand, because I presume you've had the discussion with your attorney, that voluntary intoxication is not a defense. You understand that?
Yes, ma'am.
And you had those discussions with your attorney?
Yes, ma'am.
All right. And so, Mr. Pangburn, may the court use the probable cause section of the criminal complaint with the statements made by Mr. Brown to find a factual basis.
Yes, ma'am.
Has anyone made any threats or any promises to you, Mr. Brown, for you to plead guilty to these very serious charges?
No, ma'am.
You're doing so freely and intelligently. That means you're telling the court that you fully understand what you're doing here today.
Yes, ma'am.
And voluntarily.
Yes, ma'am.
Has your attorney represented you competently?
I believe so. Yes, ma'am.
Has he answered all of your questions?
And then some. Yes, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Did he go over any possible defenses with you in your discussions?
Yes, ma'am.
Did he go over any possible lack of defenses with you in your discussions?
Yes, ma'am.
Did you inform him of all of the facts that you know to exist from this day with your attorney?
Yes, ma'am.
You've discussed with him all that you know to exist from your perspective.
Yes, ma'am.
And so you're satisfied with your counsel's services.
Yes, ma'am.
All right, Mr. Pangburn, do you believe your client understands the nature and the purposes for today?
Yes, ma'am.
Do you believe he's entering the plea freely, voluntarily, and intelligently and knowingly?
Yes.
Do you believe he understands the elements of the crimes and the facts that support each of these elements?
I do.
Do you believe that he understands the maximum possible penalties that he faces today?
Yes, ma'am.
Do you believe he understands his constitutional rights and what he's waiving here today?
Yes.
And did you thoroughly go over with him the fact that it's the court's discretion in what I sentence here today?
I did.
And so you believe he's entering pleas freely, voluntarily, and knowingly?
Yes, I do.
All right.
Was there a deportation warning?
Yes, there was. Mr. Brown, do you have any questions before we proceed here today?
No, ma'am.
As to count one, intentionally point a firearm at a law enforcement officer, a firefighter, an emergency medical technician, an H felony. How do you wish to plead?
Guilty.
As to count six, battery or threat to a law enforcement officer, an H felony. How do you wish to plead?
Guilty.
As to count eight, failing to comply with an officer to take a person into custody, an I felony. How do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those three crimes. The rest of the charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Renicky.
Thank you, Your Honor. As the court is aware, this is a somewhat complicated case. Originally, it started out in 23 CF 130, where we had 7 counts. And at the eve of trial, prior counsel made a motion essentially saying that they wanted a more definite statement, in part because in some cases there were what I would call technically multiple crimes against the same victim. For example, striking an officer and then threatening an officer. And then the original case was dismissed without prejudice. The second case, which is the 24 CF 79, was brought. So that was how it went from 7 felonies to basically 14 felonies. The underlying facts really haven't changed. And I think they are fairly well set forth, but just to paraphrase, in the wee hours of the morning, the Grantsburg Fire Department returned to the fire station from an unrelated call involving either an ATV or a UTV rollover accident. And while they were basically coming back to the fire department and putting their equipment away and processing the way they were supposed to, somebody noticed that there was looked like a dark form in the street, and somebody went out to investigate, and lo and behold, it was a human that was still alive but laying in the street in the dark, basically. And so they determined it was Mr. Brown and that he was still alive. And so Chief Barnett, as well as another EMT by the name of Robert Jorgensen, the two men or two fire personnel, Chief Barnett and Robert Jorgensen, went to aid Mr. Brown. And it turned out that he appeared to be drunk and either sleeping or passed out in the middle of the street near the fire station. And so upon waking him up, he gets up rather unsteadily and was somewhat hostile and combative, and they had words back and forth, but then they essentially told him to go home, and then they stood there and watched him as he either walked or, I suppose more accurately, more or less staggered into his house. They saw him get inside safely, and then they saw the lights inside the house turn off. And so as the two men turned around and went to leave to head back to the fire station, somebody looked back and noticed that the lights were coming back on. And not only did they come back on, but then Mr. Brown came out and re-exited the house. And this time, it appears that he has something in his hands, and lo and behold, it was in fact a pistol. It was a real pistol. It was a 9mm, and it was in fact loaded with a round in the chamber, or the action. And as he came out of the house, he was holding it, I guess it could be described as in a combat position, and he was kind of sweeping the area as if he was essentially looking for targets. And then in my discussions with Chief Barnett, I believe after the initial preliminary hearing and the initial file, to get clarification, Chief Barnett, I remember telling me that essentially they made eye contact, and the defendant, Mr. Brown, actually pointed the gun at him and then took approximately 12 or so steps directly in his direction while aiming the gun directly at Chief Barnett. And so as they got closer, when they got close, Chief Barnett had the presence of mind to speak in an authoritative voice, knew that Mr. Brown was an ex-Marine, and basically said words to the effect, "Hey, Marine, put the gun down," or something to that effect. And then Mr. Brown actually responded and put the gun down. And so fortunately, nobody got shot, but as we heard earlier from Chief Barnett as the victim, it obviously had a major effect on him. Chief Barnett ultimately then picked up the gun, saw that it was a real gun, saw that it was loaded, and he was able to eject a shell to clear the gun so that it was not loaded. And after clearing the shell, the defendant takes a look at him and apparently gets angry for what he thinks is wasting ammunition, and then starts to verbally threaten Chief Barnett's life, saying that he's going to kill him because he's wasting ammunition. So at that point in time, or shortly before that, or when they see the pistol and Mr. Brown coming with the pistol in his hands, EMT Robert Jorgensen then turns around and runs back to the fire station. So Chief Barnett was there alone at the time that the gun was later put down and then recovered. Chief Barnett took custody of the gun and the bullet and the clip, and then kept it safe and then turned it over to, I believe it was Brady Mangan, the Siren police officer who was a mutual aid help at one of the multiple officers that were there. eventually, James Brown goes back into the house. And again, it could have more or less ended there, or at least the danger part ended there. But around this time, the other law enforcement officers start to arrive, either the SWAT team or the multiple officers from multiple jurisdictions. They try to determine what's going on. They take positions in the area, trying to keep everybody safe.
A loaded gun was pointed at first responders, yet the plea deal shocked the entire courtroom. Victims say their lives were changed forever, while the judge questions whether justice is truly being served. Did this former Marine deserve probation, or something much harsher? Watch this emotional courtroom battle and decide for yourself. Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more shocking courtroom moments.
And at some point in time, while they're still trying to figure out what to do next, Mr. Brown exits his house a second time. And this time he has what appears to be a long rifle in his hand, and he's more or less doing the same thing where he's sort of sweeping it around as if he's looking for targets. Deputy Noah Barker is, I think if I've got my facts right, somewhere between 80, 90, or 100, I'm not sure if it's feet or yards, but he's some distance away, basically at around the corner of a house, somewhat behind or near a air conditioning unit. Other officers are in various other areas kind of surrounding or semi-surrounding the area. And various law enforcement officers are instructing the defendant to put the rifle down, and he refuses to do that. And then at some point in time, he's like in a, he walks, so he's essentially near a neighbor's house. And ultimately, Siren Police Officer Brady Mangan is there. Deputy Sheriff Chad Brugman is in the immediate area. They're all telling him to put the rifle down, and he's refusing to put the rifle down. And at some point in time, a lady who's, I think, a social worker is in the area. She comes by, she knows Mr. Brown, and she sort of orders him to put the gun down, and he more or less gives the gun up to the lady. Unfortunately, at this point, that's Patricia Wenthy. At some point in time, the officers both threatened to and ultimately try to use a taser on Mr. Brown to get him to drop the gun. One of the tasers, I think, either struck a jacket or some clothing. The second taser unfortunately struck Miss Patricia Wenthy herself. But in any event, Mr. Brown is kind of going through alternate waves of either being cooperative or sometimes jovial, sometimes laughing, and sometimes being hostile. And when he's hostile, he's threatening to tear their faces off and to kill them and things of that nature. And so at some point in time, he actually starts wrestling around with Sergeant Brugman, who's trying to take him into custody and to handcuff him. And Brugman actually is asking the other officers to control his arms and legs to stop him from kicking him. So this wasn't simply a threat, but he was actually kicking and striking Chad Brugman before they can get him into control. And he's refusing to listen to Siren Officer Brady Mangan as far as letting himself get arrested. By then, he ultimately does get arrested and handcuffed. He's taken to the Burnett County Medical Center for evaluation. And again, he starts going through this waves of going from being jovial and happy or cooperative and being very uncooperative and being threatening. He makes some mention that he's Wolfie or Mr. Wolf or a werewolf or something like that, and he's going to bite him. And he attempts to bite Chief Siren Officer Trevor Tex as well as Deputy Jared Woody. And so he starts to threaten to kill both Chief Tex and Deputy Woody. He sort of wrestles with them and attempts to bite both of them until they more or less have to wrestle with him and get him subdued into custody yet again. And then ultimately he's taken to the jail, and then he ends up going to jail for 96 days. It turns out he has no prior record. He did have a Burnett County case back called 18 CM 269, in which he was charged with a misdemeanor battery, misdemeanor disorderly conduct, and obstructing an officer. At that point in time, Assistant Daniel Stefan worked out a plea agreement with him for a DJOC, which he apparently successfully completed. And then, depending on when and where you try to look up on CCAP, it actually doesn't even appear on CCAP anymore. But he did successfully do that DJOC. I can find no criminal convictions under his name or birth date, either in Wisconsin or Minnesota, so he has no prior record. Clearly, this is a dangerous and disturbing situation, and I can feel for the law enforcement and the victims, and I understand their frustration. Originally, we were going to ask for a PSI, but we both decided to waive the PSI. I know the last time the court was concerned with what his prior record was, and that's why we looked for it and can't find any other than the prior 18 CM 269 DJOC. Part of the thinking that went on in this case is this was a multi-jurisdictional investigation. To be perfectly candid, all of the police reports were not as clear as they could be because essentially it was turned over because during this melee or this chaos or this situation, Deputy Noah Barca did fire his service rifle at the defendant, I believe 3 times. We don't know exactly where the bullets went, but fortunately they didn't strike anybody from the defendant to anybody else. Because there was an officer-involved shooting, it was investigated by Polk County. When we got basically the Burnett County deputies and the local police officers were essentially told not to write up reports and it was going to be investigated out of the county. So essentially they didn't. And then when the out-of-county officers investigated, they basically investigated as to whether or not the officer-involved shooting was justified, and they never investigated as to what, if any, crimes were committed or what crimes would be referred. So I had to piece together literally hundreds of pages of investigation, hundreds of hours of either investigation, listening to tapes, videotapes, in terms of getting even the charge regarding Chad Brugman, which seemed to be relatively clear. He never affirmatively reported, and nobody ever affirmatively wrote down that the defendants kicked Chad Brugman. I had to glean that from the fact that Chad Brugman told people, control his legs and get him to stop kicking me. So I had, intuit that he was therefore kicking Chad Brugman. And so the case, as the court is aware, was on the eve of going to trial. I think it was in February. We had these motions for clarification or for more definite statements. Essentially, the prior attorney was asking me to essentially bring more charges to make everything clear so that the jury wouldn't be confused, which is what I did. But we believe, in spite of the fact that there's 14 counts, the original 7 were actually appropriate, and we're essentially getting a felony conviction for each of the major types of criminal activity. Now, as the court is aware, it's kind of a pig in the poke or a little bit less consistent than we would like as far as PSIs and their recommendations. But in this case, other than Noah Barker shooting, unfortunately not hitting anybody, but nobody else physically got what I would call seriously hurt. There's psychological trauma. Maybe there's some workers' comp restitution going on for people that missed work. There was a couple of wrestling matches. But all in all, we believe that this does comport with the public interest. Clearly, the defendant has mental health issues by having a felony, as the court is aware, and as the defendant was informed in the colloquy, he no longer has the legal right to legally possess a firearm. Sobriety and AODA issues are probably paramount. He says he's got lack of sleep and he's got large amount of alcohol consumption. And so this is the type of thing, and he has spent a relatively immediate punishment of 96 days of jail. Now, 96 days of jail isn't prison, but on the other hand, it was without work release, and it was the original 96 days. He posted a large quantity of cash. Since he's been out, we're unaware of any bail violations. And so I believe that a withheld sentence and 3 years of probation on all 3 counts is actually appropriate and not too far out of the realm of what fits the facts of this case. There's the 96 days of jail. On a withheld sentence, if he does violate his probation, he can be revoked and come back to court for further sentencing at a later date. and possibly get a maximum consecutive executed sentence at that time. But for now, I don't see any real reason why he can't be essentially treated within the community and supervised within the community. So we would ask the court to follow the joint recommendation. I'm not sure what the restitution is, but I imagine our victim witness agent has filed requests for restitution if there is any. Otherwise, the usual fines, fees and DNA sample and court costs for all 3 counts.
Thank you. I don't have any requests for restitution. Is there any? No. All right, no restitution is being requested. Mr. Pangburn, I am now going to turn to you for argument and sentencing recommendation, please.
I don't mean to interrupt, but I've got in the notes here $1,814.11 for
Let me stop.
Workers' comp medical to Jared Woody.
With Jared Woody?
Right.
With any of the victims that I have present here today, is anyone asking for restitution? I can set a restitution hearing. I don't need figures here today. If there's anyone, please raise your hand. I see no hands. I have a request apparently in notes from DA Renicky that's requesting restitution from Officer now Chief Woody. I'll follow up on it. All right, so I'm going to give 30 days perhaps for restitution hearing request. All right, Mr. Pangburn.
Thank you. I'd like to speak primarily about Mr. Brown's background. I think it helps to understand how we got here today. If we can understand something about him and his life, it's an unusual set of circumstances from what he's described to me. He was not originally born in the United States. He was born in Russia. He lived there for 6 years. His mother apparently passed away. She had some mental illness issues as he does, and she passed away when he was approximately 2 years old. He said he was a toddler. His biological father was quite abusive. He ended up living with his biological father until the age of 6. Until a family from Tennessee that was looking to adopt and apparently decided they wanted to adopt a Russian child, ended up adopting James and bringing him to the U.S., where he eventually became a United States citizen. As a teen, he was diagnosed with PTSD as a result of the abuse that he had suffered at the hands of his father when he was a young child. And he was diagnosed with ADHD as well. When he graduated from high school, his adoptive parents wanted him to go to college. It wasn't really what he felt was the thing for him, but he went. And it turned out it wasn't for him, and he lasted there about 1 year before he left. Spent some time just kind of moving from job to job, and then when he was 25 years old, he decided he would join the United States Marine Corps. That is a bit unusual for someone who has ADHD, I know from experience, because my son couldn't join the military because he had ADHD. And when I mentioned that to Mr. Brown, he said, well, the recruiter said to keep it to myself, and if I wasn't on any medication that would show up on a drug test, that the Marine Corps wouldn't know. So he kept it to himself, and he stopped taking his medication, and he got into the Marine Corps, which obviously was probably not the ideal situation, but it's what happened. So he served from 2010 to 2015. My understanding is he received an honorable discharge. He was primarily doing computer IT type of work. They provided him with the training that he needed for that, the education, and then he did that work for the 5 years that he was in the Marine Corps. He said prior to that, he was 25 when he went in. Prior to that, he didn't have an alcohol problem, but while he was in the Marine Corps, that is when he really started drinking. I don't know if that was a cultural issue. I didn't ask him that, or if that was in response to stresses of being in the Marine Corps. I don't know, but that's when he started developing a drinking problem, was when he was in the Marine Corps. He got out in 2015, and then he obviously had a span of about 8 years from 2015 until this incident in 2023. Where, as he describes it, he kind of went from place to place. There were various times where he was homeless, as a lot of veterans unfortunately are. He continued to suffer from his mental illnesses. He continued to consume alcohol. He worked jobs when he had them. And eventually he ended up here in Wisconsin because his father, his adoptive father, is from here, grew up in the house that he lives in now. That was his grandmother's house. And he asked James to move into the house when she had to go to a nursing home to take care of the house. And now James owns the house and he still lives there. So that's how he ended up here in Wisconsin. But even then, he was still primarily alone. He tells me that during that pretty much 8-year period until this incident, he tried to deal with things on his own. He kept himself very isolated. He consumed a lot of alcohol, sometimes worked, sometimes did. I mean, it's unfortunately, I think, kind of not so unusual story, right? As far as what happens to people who have mental illnesses, who have substance abuse issues, who have trauma. Some are veterans, some are not. He happens to be a veteran. That's certainly not exclusive to people who have these problems, but it's not uncommon for people who have these problems to be veterans. After this incident, he tells me he stopped drinking. I don't know. There's been no bond violations. He's been on bond for about 16 months. He's been out of custody for about 13 months of that 16 months, and I'm not aware of any bond violations. The thing that seems to be most positive for him now is he tells me in December, he told me the day, on December 10th, 2023, he met his girlfriend who's here with him today, and now they live together. And he said that's been a very positive experience that has helped him turn his life around. And she tells me too that she has not seen any drinking from him since she met him on December 10th, and he seems much happier and healthier. And as I indicated, he was spending a lot of time intoxicated and alone. And he's not intoxicated anymore. He's not alone anymore. And that seems to have been helping him quite a bit since he got into this relationship, which makes sense because being alone when you have these issues and being impaired a lot and using substances is not going to lead anywhere but a bad place. And he describes that he would go in a downward spiral and things would just get worse. And like, as he said, he wouldn't sleep for days at a time. There's holes in his memory because he was impaired, but he seems to be doing substantially better now. He is working. He's been at not terribly long, but since July of 2024. I don't know this company. He says it's called Equus Magnificus. They make horse treats, apparently. He seems to really like it. We spent quite a bit of time today talking about his job. He works third shift there, 40 hours a week. So he seems to, he's working, he's sober, he's in a relationship. And as I indicated, he seems to be doing much better. He has no prior record, as was indicated. Apparently there was an issue. I didn't see it on CCAP, so I wasn't even aware that he had the prior charges.
For the record, I am aware of 18 CM 269. That case was in front of me. It was a DJOC. I'm well aware of that case. I'm well aware of the DJOC. I'm well aware of it being dismissed. I have access to that DJOC.
Right. I understand. So no prior criminal convictions. He obviously spent 96 days in jail, which is a significant punishment for anybody, especially when, as indicated by the state, you don't get to leave and go to work or do anything else. It's just time that you're in custody. Clearly, there is a need for rehabilitation that we hope can be accomplished on probation. There, as indicated, he has a medical issue, which is ADHD, which can hopefully be treated with medication, and he has the mental health issue, the PTSD from his childhood trauma. He's doing his best to deal with those on his own, but I don't know that he's adverse to accepting help through probation if additional help that seems to be necessary. And he's got the substance abuse problem, and certainly anybody who has a substance abuse problem can benefit from AODA classes. So I'm sure the DOC would do both of those things if he were to be placed on probation, which will assist him with rehabilitation. I think being on probation provides a level of protection to the community because there's oversight. There's obviously punishment because he served time in jail. And there is a significant deterrent effect, I think, by being on probation because he knows, as the court told him a number of times that he's facing a significant number of potential felony longer felony sentences if he's revoked. You know, he's got 2 Class H felonies, 1 Class I felony. So he is facing a significant amount of time, which I hope would have a deterrent effect. He does not own any other firearms. The one firearm that was taken on the night of the incident is the only firearm that he owned. He has not obtained any since then, and now he understands that he can't own a firearm. So I think that provides some protection to the community as well. I understand the sentiment of the individuals who were here speaking today, but I agree with the state that I think we fashioned a sentence that is appropriate under the facts of the case, Mr. Brown's background, and the sentencing objectives that are laid out for the court to follow. So we would ask the court to follow the joint recommendation.
Thank you. Before I proceed to ask Mr. Brown if he has any statement to provide to the court. Mr. Brown, how long were you in the Marines? Well, I think you said, I got that from your attorney, 5 years in the Marine Corps. Where did you serve?
Quantico, Virginia.
Served in Virginia? You didn't go to Iraq?
They wouldn't let me.
So you didn't fight in a war?
They wouldn't let me.
So you just went to Quantico?
They literally would not let me. I tried to get moved to other stations, but every time that I did, they extended the time in service all the way up to a home front.
All right, I'm trying to understand. I know a lot of veterans, and I understand PTSD with veterans, and I understand anxiety with veterans and other disorders with veterans, and usually that comes with combat. And so that's why I was just trying to understand where you were stationed, and you were just stationed in Quantico?
Yes.
Now, you were diagnosed with PTSD as a teen, and I presume that, as your attorney stated, that had something to do with probably your childhood in Russia.
Yes.
And then did you have PTSD related to your service then?
No.
So your PTSD just stems from Russia, not from the Marines?
Correct.
So then you were diagnosed with PTSD when you were a teen, as well as the ADHD?
Yes, ma'am.
Were you ever on any medications for either of those?
I was on ADHD meds up until I was 18 years old. And then I got off of them because I wanted to join the Coast Guard at that time, and they said they couldn't take me because I was on ADHD meds. So I stopped taking them then. And then PTSD, I was in and out of therapy pretty much until I was an adult.
Till 18?
Yes, ma'am.
So did you ever take any anxiety medication?
No, ma'am.
They go hand in hand.
No, ma'am,
Usually PTSD, anxiety.
As far as I
ADHD.
know, I never took anything for anxiety. No.
So you've never had the mental health evaluation?
No, ma'am.
So the last time you've been in therapy was when you were 18 years old?
Officially, yes, ma'am.
So from July 2nd, 2023, after this very horrific, traumatic, terrible incident, you've not sought any treatment or services or anything of that nature?
Oh, I went to one session with a therapist that was with the VA, but she kind of set me off because she basically claimed that I was just there to get a diagnosis.
So she set you off?
Yes, ma'am.
And so you didn't want to go back again?
Yes, ma'am.
So that was it?
Yes, ma'am.
That's all you did?
Yes, ma'am.
After July 2nd, 2023? After causing all of these terrible actions and trauma to a lot of people in the community and all of this violence and risk of harm, one time you went to a therapy session and she set you off and that was it?
No.
Yes or no?
Yes, ma'am.
A A former Marine pointed a loaded gun at first responders, threatened officers, and turned a quiet night into chaos. Now, after emotional victim statements and shocking courtroom testimony, the judge faces one difficult question: is probation enough for a case this serious? Watch this intense courtroom showdown and decide for yourself. Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more shocking courtroom moments.
All right. Mr. Brown, I'm now going to give you an opportunity to tell me anything that you wish for me to know, anything at all. This is your only opportunity. This is for you to tell me anything you wish for me to know and understand about you. This is for me to know and understand about your actions that day. Any remorse you may have, anything at all, or you may be quiet and stand mute. You do not have to tell me anything, but this is your one and only opportunity. You may begin.
I gotta be honest with you. I understand that what I did was, for better lack of the words, just royally horrendous.
That's putting it very, very mildly.
Okay, well, let's go back. Okay, well, let's go with what I originally wanted to say. I'm literally tempted to ask the deputy to hand a gun to Chief Barkley and put it to my head. That's how bad I feel about this. From what I did to them, yeah, no, you might as well kill me. My integrity is shot. What I did to a fellow Marine that's horrible. So I don't know what else to say. I'm sorry, but those two words they don't fix anything. So my life is yours. Do with it what you will. I got nothing. My life is literally filled full of regrets, things I should have done that I didn't, things that I could have done that I didn't, things that I did do that I shouldn't. Life is filled full of regrets. This one, is there anything else you want to say? Kill me. Just kill me. I don't care.
No, that's not what courts do. And that's not what the justice system is. The justice system is for multiple things. It's to look at the effect of the victims. It's to look at punishment. It's to look at deterrence. It's to look at the public interest. It's to look at the community and keeping it safe. It's to look at accountability. It's to look at remorse. It's to look at a lot of things. It's not to kill a defendant. Should have, would have, could have. Those are words that I hear a lot, or I should hear a lot from defendant. And those are words that are said a lot because I should have done things differently. I would have done things differently. Oh God, I wish I could have done things differently. And then the pain of all the people in this room, in the community, in this world would not exist. Should have, would have, could have. But we're here today. We can't go back in time. We can't change the way things happened. There's not a magic wand to fix everything, or I wish I could, because I have heard pain here today. I have heard pain from the people that you have affected. And I'm going to tell you that the people who spoke here today are not the only individuals who have been affected by your conduct and your behavior.
Interesting.
It hasn't only been law enforcement officers. It hasn't only been firefighters. It hasn't only been medical professionals. It hasn't only been emergency response teams. It has been the community as a whole. There was an entire community, an entire town that you put at risk that day. You put at risk. But for the love of God, God Almighty, and the bravery of the people who put on their uniforms each and every day and risked their lives each and every day, no one was physically hurt. And I stress physically hurt. Should have, would have, could have. So, there were 47 law enforcement deaths, officer deaths to date, so far. To date. Fatal officer deaths to date. Because people should have, would have, could have. And 42 gunfire, by gunfire. You could have been in that boat, Mr. Brown. You took a loaded weapon the first time, a loaded 9mm weapon, and you pointed it at an officer, at fire chief. You pointed it at somebody who risks his life for you, his life for anyone who's in this room or anyone who's in the community. Someone who, as I can say, saw you laying in the roadway, wanted to help you, wanted to make sure you were okay, knew that you were a Marine, really wanted to make sure that you were okay. Risked his own life to make sure that you were okay. And I know I shouldn't focus on the fact that our victims here are law enforcement officers. But I think it's hard not to. And I'm lumping everybody in as officers. They're not all officers. But I want to say law enforcement officers, medical professionals, firefighters, people who, again, risk their lives for us, for the public, who face daily traumas from their work, their everyday work. They wake up every morning and they stick one leg in after the other into their uniformed pants. And then they put on their shirts every day to risk their lives. each and every day. And you've heard from 3 of them. Daily traumas of these people, that their work often turns them into someone their loved ones may not often recognize, as you heard. Sometimes they may not even recognize themselves from what they go through. This trauma is poisonous, cumulative. It's like cancer. It affects their mental, emotional, physical, spiritual health. It affects their ability to maintain close and meaningful relationships. It affects their ability to sleep. It affects their physical well-being, like their physical health, such as whether or not they have physical disorders, such as heart conditions or other such conditions. It devastates their quality of life if it's left untreated. It can often lead them to feel emotionally dead or numb, unable to connect with people. And after incident upon incident of this occurring with people who do such things like you did that day, putting people's lives at risk, taking a loaded weapon, and this happened more than once that day. And it happened with Deputy Barker, and it happened with Sergeant Brugman, and it happened with the chief firefighter, and it happened with numerous other individuals, and then it happened later with Chief Tex while you were being arrested or at the hospital. These incidents build, and they build. And as you heard, that it sometimes causes self-destruction. They're victims. And I need to look at them as victims and the effect that it has. Because that's what I have to do. My job is to look at the nature and the gravity of the offense. And this is very serious. This is more serious than a possession of methamphetamine case. This is more serious than a burglary case. This is more serious than a battery case. This is more serious than a lot of the cases, most of the cases that come in front of me. And I have to look at your character, Mr. Brown. I do look at your past criminal record and the fact that you don't have a criminal record. You may have that deferred judgment of conviction. That's off your record now, and I'm not looking at that. But I do have to look at your character, and that's where I'm looking at your past, and I'm looking at your PTSD and your ADHD, and I'm looking at those conditions, and those conditions played a part in this incident. And your alcoholism played a part in this incident. And the fact that you are suffering from those mental health disorders played a part in this incident. And the fact that you did not seek treatment since you were 18 years old plays a part in this incident. And the fact that you have not sought any treatment but one time, when the therapist pissed you off and you didn't go back, plays a part in this incident. You are not seeking help. You are not seeking help. You're not seeking help.
I do believe there was a misunderstanding, Your Honor. I did seek help.
One time. You're not. My turn. Talk. Stop. One time you did. One time. Then you stopped going because she upset you. That's what you said.
I cannot get help from somebody who's not willing to help.
Exactly. Did you go again? Did you go see someone else? No. Did you go see someone else? No. Did you see someone else after that? No. One person, one. They pissed you off, you didn't like it, and you didn't see anyone else. You stopped. Since July 2nd, 2023, you stopped. You didn't seek help. You stopped. You're putting people at risk. You are a risk to the community. You are a risk to every single person in this room. You are a weapon. You are destructive. You will kill and destroy, and you have shown that. And you have not shown that you have any ability to seek services outside of any confined setting. You have had ample time to do so, and you have not. Ample time, and you have not. Because she pissed you off. Because she butted with you, because she tried to get you to do things that you didn't want to do, to admit things you didn't want to admit to, and you were done. I have to look at needing to protect the public. And again, that's where I have to look at the effects of the victim. I have to look at rehabilitating you and what that means. I have to look at undesirable behavior patterns. I may not have undesirable behavior patterns of violent incidents, but I do have behavior patterns of mental illnesses and not treating those mental illnesses, and now having an unbelievably serious and destructive and violent occurrence. I have heard arguments of counsel, and I have heard your statement. Now, if I look at these crimes and I look at all of the charges which you were charged with, which all look accurate compared to the criminal complaint and those facts that are alleged, if convicted on every single one of these counts, you have 77 and a half years hanging over your head. 77 and a half years of prison over your head. But you got the deal of a lifetime. Deal of a lifetime. With 3 years of probation as a recommendation to the court, with 15 and a half years of prison hanging over your head. 77 and a half years down to 15 and a half years with a recommendation to the court for probation. Now, I am told by my higher courts to consider the arguments of counsel and the recommendations by counsel. Give them heavy weight. They know the cases, they know the facts, they have the discovery, they have the information. I am also told by my higher courts to first consider probation unless confinement is necessary to protect the public from further criminal activity from you. Unless you need correctional treatment, meaning unless you need to be in a facility to receive treatment because you have not received treatment or sought treatment outside of a confined setting. Or if probation would unduly depreciate the seriousness of the offenses which you're convicted of. So I must first consider probation. Now, again, very serious charges in front of me. So I have to consider, is this a probationary case? Is this something where you get to have the ability to seek your services while on probation? Or is this something with probation and some conditional jail? Or is this probation, conditional jail with an imposed and stayed prison? Or is this so serious that probation would unduly depreciate the seriousness of the offense? In hearing arguments from counsel, the court wants to be able to go along with an agreement in hearing that, because in hearing the arguments, because counsel knows better. Counsel knows the case more than the court, more than what I have in front of me. I haven't really heard remorse. I hear that you're sorry for what you did. I hear that you don't recall what happened because you were really intoxicated and you didn't sleep for days at a time. As you know, intoxication is not a defense. The fact that you weren't sleeping for days at a time, the fact that you know that you have PTSD, the fact that you know that you have ADHD, the fact that you have not had a mental health evaluation to determine if you have anxiety or if you have any other mental health conditions or if you should be on any type of medication. Those come into play because they fall on your shoulders. That makes this more serious. Because I truly believe that you, left like this, are a weapon yourself. And you can snap at any time if left untreated. And you have been left untreated. That's why I had those questions, and that's why I had to ask, and that's why I had to know, what have you been doing since July 2nd, 2023? And the answer has been nothing, except refraining from alcohol, but nothing. Nothing to help your mental health. Nothing. You went to the VA once. You didn't like what she said. You didn't go back. You didn't try somebody else. You didn't go somewhere else. So in looking at this case, I have to consider the need to protect the public along with the seriousness of the offense. And it extremely overrides any rehabilitative prospects and a lack of criminal history. So with regards to count 1, intentionally point firearm at a law enforcement officer, an H felony, the court will sentence you to 3 years of initial confinement, 3 years of extended supervision. With regards to count 6, battery or threat to a law enforcement officer, the court will sentence you to 3 years of extended supervision, 3 years of initial confinement, 3 years of extended supervision. With regards to count 8, failing to comply with the law enforcement officer's command while taking you into custody, 1.5 years of extended supervision, 2 years, or 1.5 years of initial confinement, 2 years of extended supervision, immediate in custody. Conditions of extended supervision, conditions will be absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, mental health evaluation, thinking for a change, Court will assess I'm going to assess $518 in court costs and fees per count. I'm also going to assess $2,000 in fines per count. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I cannot see that any sentence less than this sentence would be appropriate. It would unduly depreciate the seriousness of the offense. Should you have done anything at all to try and seek any services or counseling or medication to try and address your needs and your concerns and your mental health issues, the court would have considered the agreement and weighed it a little bit more heavy, but I cannot, based upon the fact that you did not do that, and I find that you would be a weapon to the community and a risk to the community. 20 days to appeal. Should you fail to appeal within 20 days, again, you lose that right. The court is ordering DNA. That would be provided. This is not something that you would be able to do challenge incarceration program, and you would not be able to do the substance abuse program. They are multiple victims. Although there are multiple victims and I understand the trauma to the victims, I'm going to have them be concurrent to each other. Because he's not eligible for the early release programs.
Or we'd ask for the 96 days.
96 days jail credit, no contact with victims. Mr. Renicky, I believe I have everything covered, but what am I missing?
I think you have it covered.
Any conditions you want to see, Mr. Pangburn?
No.
We are adjourned.
Just when it seemed this case couldn't get any more intense, the judge delivered a stunning response. As James Brown broke down in court, expressing deep regret for his actions, the judge focused on one critical question: had he done anything to change since that terrifying night? What followed was a powerful speech about accountability, public safety, and the lasting trauma suffered by first responders. Then came the moment that changed everything, the sentence. Was justice finally served, or was it still not enough? Watch to the end and decide for yourself. Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more shocking courtroom moments.